Alex here with a hearing video on the state of Nevada versus Roger Hillygus. As you may recall, we provided electronic coverage of a hearing recently in this matter where District Court Judge Barry Breslow said,
"I run the show here, not you. That applies for today and forever. We're going to set this for a hearing next week. I'll take up the issue of whether and you will be able to represent yourself, and those proceedings will not be open to the public other than as allowed by law."
We filed a media request, and Judge Breslow failed to rule on that request, which led to an article on the issue published by This is Reno, a local media outlet operating in northern Nevada. In the article, I do directly confront the court for its noncompliance with Supreme Court Rule 230 sub 2 and Solid v. 8th Judicial District Court, and I would suggest all of our viewers read the article because it goes into the importance of camera access to criminal proceedings and also mentions similar issues other media outlets like the Reno Gazette-Journal and Colo TV had recently in an unrelated case before District Court Judge Kathleen Draculich, also of the 2nd Judicial District Court. Attorney Luke Busby filed a motion to intervene on our behalf, citing potential First Amendment violations. Deputy District Attorney Amos Stege filed a response acknowledging our media request, but in opposition to the court granting our request to intervene, suggesting that the procedure and court rules would be complied with going forward. Mr. Stege's filing asserted that Judge Breslow simply had no idea we had even submitted a media request, a notion I find very difficult to believe. The media request was first provided in writing to Court Administrator Alicia LaRude, Department JEA Christine Poole, and Law Clerk Hannah Martinez. A follow-up email was sent the next day to Chief Judge Scott Freeman through his Department JEA, Brianne Ward. The in-person interaction with camera operator Christine Toasty undermines any plausibility that this was all just a series of unfortunate accidents or mistakes, given she repeatedly told court personnel that a request had been submitted, insisting they double-check, and despite all of this, was told the judge would not allow any recording of the proceeding. You can find a link to the article, motion, and response down in the description below, as well as sworn statements detailing the issue. I have been able to glean that what apparently occurred during the hearing was a lengthier version of the Faretta canvass and competency examination conducted earlier in the case by Justice of the Peace Ryan Sullivan. Mr. Hillygus remains competent to stand trial and has apparently been allowed to represent himself. Another question that I am anticipating has to do with pulling of a JAVS video of the proceeding. Apparently, no JAVS recording of this particular hearing was made. I also asked about a transcript and was told by court reporter Isolde Zinn that it'll cost $80. We will probably end up pulling these transcripts for other reasons, at which point a link of it will become available down in the description below. The Rittenhouse trial coverage makes clear both the public's interest in criminal proceedings as well as the positive impact camera coverage can have on these cases with regards to transparency and public confidence, and I'll try my best to continue to try to cover this and other cases despite resistance encountered. As with our previous videos, feel free to post any questions you have down in the comments below, or you can send us an email at media@ournevadajudges.com.